Welcome to our deep dive on the J-1 2-year home residency requirement under INA 212E. In this video, we will explain what triggers the requirement, why timing on the skills list matters, how funding sources are evaluated, and why the Department of State advisory opinion is often the decisive authority. We will also cover implications for H-1B and green card eligibility, outline waiver options, and give you practical steps to build documentation. Along the way, we will include diagrams, examples, and quizzes to help you master this topic. First, let's set the stage. The J-1 Exchange Visitor Program is widely used by scholars, researchers, and medical trainees. However, some categories of J-1 status come with the 212E home residency requirement. The result is that some J-1 visitors must return to their home country for a cumulative 2 years before becoming eligible for certain benefits, such as H-1B status or adjustment of status to permanent residence. This video aims to clarify when and why 212E applies and how to plan around it. Before we proceed, please note that this content is for educational purposes only and does not constitute legal advice. Every case is fact-specific. You should consult a qualified immigration attorney for personalized guidance. Next, here is our roadmap. We will define the J-1 212E requirement. Then, we will examine its two common triggers: timing on the skills list and direct or indirect government funding. After that, we will explain the decisive role of the Department of State advisory opinion compared to the preliminary DS-2019 notations. We will also discuss the impact on H-1B and green card applications, offer a documentation strategy, review waiver pathways, and finally, reinforce learning with diagrams, timelines, and quick quizzes. To begin, the 2-year home residency requirement applies to some J-1 exchange visitors and requires spending a cumulative 2 years in the home country before eligibility for certain immigration benefits, including H-1B status and adjustment of status to permanent residency. You can satisfy the requirement either by completing the 2 years physically in your home country or by obtaining a waiver. While you may have initial notations on your DS-2019, the Department of State advisory opinion often provides the binding determination of whether the requirement applies. Until it is fulfilled or waived, the individual remains ineligible for H-1B and adjustment of status, regardless of job offers or other qualifications. Here is a flowchart of common triggers. We begin at the point of J-1 visa issuance or initial entry. We then check 3 main areas: whether the visitor's field and country were on the skills list at that time, whether there is government funding either directly to the visitor or indirectly through institutional grants, and whether the program involves graduate medical training. A yes on any of these typically leads to being subject to 212E. The Department of State advisory opinion can confirm or, in limited instances, correct the initial assumptions. Finally, all paths converge on the result that the person remains ineligible for H-1B or adjustment of status until the requirement is either fulfilled or waived. Moving on. The skills list timing is crucial. The requirement is based on whether your home country and field were on the skills list at the time your J-1 visa was issued, or when you initially entered the United States in J-1 status. If your country and field were listed then, you are subject to 212E, and subsequent removal from the list does not usually retroactively eliminate the requirement. Once triggered, it remains attached to that J-1 status unless you obtain a waiver. Therefore, you should keep accurate records of your entry date, DS-2019 forms, and a contemporaneous copy or reference of the skills list at that time. Next, funding is often misunderstood. Direct or indirect government funding, from either the United States or the visitor's home country, can independently trigger 212E. Even if you believe your support is solely from a private university or affiliated hospital, the money may originate from federal grants. When you seek an advisory opinion, the Department of State reviews the complete funding chain, not just what appears on the DS-2019. Therefore, request a comprehensive funding letter from your sponsor that identifies the original sources and how funds flow to your position. Continuing, the Department of State advisory opinion is often the decisive authority regarding whether you are subject to 212E. It can contradict the initial DS-2019 notations. When it indicates you are subject, that generally controls the subsequent USCIS adjudications for H-1B or adjustment of status. If you believe the advisory opinion is incorrect, the burden falls on you to provide detailed, credible documentation that demonstrates the error. Now here is a practical sequence to follow. First, confirm your visa issuance date and initial J-1 entry date. Second, collect every DS-2019 and any offer letters or program descriptions. Third, ask your sponsor for a detailed funding letter that maps the flow of funds from the original source to your compensation. Fourth, prepare a concise cover letter that sets out your understanding of whether you are subject and why. Fifth, submit the advisory opinion request to the Department of State following the current published procedures. If the advisory opinion is adverse and you believe it is incorrect, compile concrete evidence such as grant numbers, budgets, and subawards to rebut it. If it is correct and you are subject and you have no factual dispute, evaluate the available waiver options with qualified counsel. This timeline lays out the sequence from J-1 visa issuance or entry through program start, recognition of potential funding triggers, and documentation review. It then shows the request for a Department of State advisory opinion and the resulting determination. If the determination is that you are subject, the path splits. Either fulfill the 2-year requirement abroad or pursue a waiver through one of the available avenues. Only after the requirement is fulfilled or a waiver is approved should you proceed with filings such as H-1B or adjustment of status. Now, regarding downstream immigration plans, it is usually not viable to secure H-1B status or adjustment of status while still subject to 212E, unless you first satisfy the requirement or obtain a waiver. United States Citizenship and Immigration Services typically relies on the Department of State advisory opinion, so you should plan accordingly. A compelling job offer will not overcome 212 by itself. The sequence and timing of your waiver or fulfillment are what matter. Align cap seasons and waiver timelines to minimize interruptions. Let's compare the DS-2019 with the advisory opinion. The DS-2019 is the initial program document and may include a preliminary assessment related to 212E. However, it may not capture indirect funding details. When there is a discrepancy, the Department of State advisory opinion is generally controlling. The advisory opinion involves a more thorough review of the funding chain and is heavily relied upon by USCIS, effectively overriding conflicting indications on the DS-2019. Here is a summary of the 5 waiver pathways. First, the no objection statement applies to many J-1 categories, but can be limited for those with U.S. government funding or certain medical training. Second, the interested government agency route is for cases where a U.S. agency asserts that the public interest in your continued work outweighs the need for you to return. Third, the persecution waiver addresses credible fear of persecution on protected grounds. Fourth, the exceptional hardship route requires demonstrating hardship to a U.S. citizen or permanent resident spouse or child that goes beyond normal separation. Finally, the Conrad 30 program is for certain J-1 physicians who commit to serving in designated underserved areas, with state-specific procedures and constraints. Quiz time. Question: if your home country and field were on the skills list at the time of your initial J-1 entry, but they are removed 2 years later, are you still subject to 212E from that J-1? Options: A. No. Removal retroactively cancels 212E. B. Yes, you remain subject unless it's waived. C. Only if your DS-2019 says so. D. It depends on your future employer. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is yes. You remain subject unless it is waived. The reason is that the trigger is the skills list status at the time of visa issuance or initial J-1 entry. Later removal does not typically retroactively erase the obligation. Second quiz. Question: a university pays your stipend from a general account. Later you discover the account is funded by a federal grant. Could 212E be triggered by indirect government funding? Options: A. No. Only direct payment to you counts. Yes, indirect funding can trigger 212E. C. Only if the DS-2019 lists the grant number. D. It depends on whether you switch to H-1B first. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is yes. Indirect funding can trigger 212. In advisory opinions, the Department of State examines the full funding chain. If the funds originate from a government source, that can be sufficient to trigger the requirement. This pie chart simply visualizes the 5 waiver pathways. It is not meant to represent statistical proportions, but to reinforce the categories available: no objection, interested government agency, persecution, exceptional hardship, and Conrad 30. To summarize the essential points. The skills list is assessed at the time of issuance or initial entry, and later changes typically do not undo the requirement. Government funding, even when indirect, can trigger 212E. The Department of State advisory opinion generally overrides conflicting indications on the DS-2019. You cannot proceed with H-1B or adjustment of status until the requirement is either fulfilled or waived. If an advisory opinion is adverse, assemble a thorough evidentiary record or evaluate waiver strategies. As a quick recap in note-friendly form, keep copies of all DS-2019s, your entry stamps and I-94, detailed funding letters, and any grant identifiers. Act early by requesting the advisory opinion as soon as you suspect 212E may apply. Plan to align waiver processing timelines with H-1B cap seasons or job offer milestones to avoid interruptions. In closing, know precisely what triggered your 212E and when. Obtain a Department of State advisory opinion and analyze it carefully. If you are subject, decide between fulfilling the requirement or pursuing a waiver that fits your facts. Coordinate your approach with an experienced immigration attorney so that your waiver timeline aligns with your career plans. Before we end, we would love your support. Please like this video, share it with colleagues who may benefit, and subscribe for more in-depth immigration explainers. Finally, tell us in the comments which part of 212E you want us to explore next, or any questions you want answered.